Good morning, Your Honors. If it please the Court, I'd like to reserve 2 minutes of my time for rebuttal argument.
Certainly.
Thank you. And may it please the Court, Joshua Hedrick here from Knoxville on behalf of Demetruice Bennett. Demetruice Bennett's convictions should be reversed for 3 reasons. First, it was error to admit proof of a possession of a different gun on a different day. And second, in the alternative, Mr. Bennett was deprived of the right to counsel where trial counsel failed to object to the admissibility of the gun. And third, that the evidence in this matter was insufficient as a matter of law. And I want to focus on the first 2 points today. I'd like to begin by the discussion of the possession of the gun. I know that Your Honors are likely familiar with the basic facts, but in this case, there was a lady, Ukiah Pelcher, I hope I'm saying her name properly, who claimed that Mr. Bennett was in possession of a black and brown gun. That's page 36 in the record. And the state sought to introduce a video of Mr. Bennett in possession on a different day, separated by several months, of a black gun. The trial court observed, both in the record at 55 and in the written record in Volume 1 at 64 in the trial court's opinion relating to the motion for new trial, the trial court observed that it may or may not have been a different gun. And I say that because the trial court sort of takes both positions respectfully. The trial court accredits the strategy of drawing distinctions between the weapons, but then the trial court specifically says that the video of the gun from the prior date was relevant to show that he possessed the same gun on this date. So inherent in that, I think, is the trial court making the finding that it is the same gun because the trial court says there is relevance in it being the same gun.
How did the trial court instruct the jury that they could view the gun, view the video?
There was no limiting instruction given. The video was presented to the jury, as the record seems to indicate, sort of without comment. The difficulty was, and I will tell Your Honor that.
So the trial court didn't instruct you can't use this video for propensity or anything like that?
There was the date there was the different date, right? That the indictment charged on this date, and the instruction said you must find he was in possession of this firearm on this date. And the record indicates that the video was clearly a different date. I think there was it was July and September was the time span. But if I'm incorrect, I'm happy to be corrected. But my recollection of the record is that there was no limiting instruction. So the problem becomes compounded by the verdict we have in this case. And the difficulty that we have is Mr. Bennett was charged with aggravated assault, he was charged with reckless endangerment, and he was charged with possession of a weapon by a felon. The jury rejected the aggravated assault in favor of, they acquitted on aggravated assault and convicted on simple assault. The jury acquitted him entirely of the reckless endangerment and then convicted him of being a felon in possession of a firearm. Now, the testimony at trial from Ms. Pelcher, who was the only...
We don't have to have consistent verdicts, do we?
So the inconsistency is not automatically a problem. And I'm not advancing the argument that I recognize that the law is we do not have to have consistent verdicts. But I think what we can learn from this verdict is that the jury appears to have considered something that they should not have. And by that what I mean is the jury appears to have rejected the idea that Mr. Bennett brandished or threatened anyone with a pistol on that day.
You're asking us to jump into the mind of the jury. We have no idea what we're thinking. That's one of the reasons we say that you can have inconsistent verdicts, because there's no way for this court or any court to determine what they were thinking, why they did what they did. As long as the evidence supports the verdict they returned, we're not to question why they came up with the random verdicts that they may have come up with.
So is there anything in the record that supports what you're advancing to us, that the jury considered the wrong date?
Respectfully, I think so. Although you have to reason from what is not in the record. And
Well,
if I
so
may,
then that gets back to Judge Dyer's issue. You're asking us to speculate about what the jury did or didn't do.
I don't think I am. And the reason I say that respectfully is there is no testimony that he committed a simple assault. There's no testimony that he touched her. There's no testimony that he placed hands on her. There's no testimony that he threatened her other than the phrase, "I'm going to shoot you." So the only way you can get to simple assault is if you entirely reject her testimony. And if that's so, then the only pistol that you have in front of, the only proof you have of a pistol's existence is the video from the prior date. And that is where the problem is. That's where the prejudice is shown by the admission of that previous pistol, right? That the difficulty is that by presenting this inadmissible evidence to the jury comes to the conclusion that there was a gun, when we know the jury has rejected the concept of there being a gun. The jury has said in the aggravated assault count, there was no gun.
That's not what that necessarily means, though, because we don't know why they rejected that count. That's the point. I mean, I get your argument, right? Mm-hmm. That the aggravated assault is based on the weapon. We don't know why they rejected it.
Well,
We don't. I mean, for all we know, there was a juror in the back that said, "I just refuse to do this."
I think we should, but don't we have to presume that the jury followed the instructions? And if we presume that the jury followed the instructions, then they would have gone
The
through.
jury can follow the instructions, yes, but all you could have is one juror to say, "I don't believe there was a gun." One. Mm-hmm. You could have all the rest of them saying, "I believe there was a gun," but since they couldn't reach a verdict, they went to the next count. That would be following the instructions.
But we know that's not true here.
But also,
because
the
they
jury-
convicted.
Let me ask this
Sorry.
question. If the jury followed the instructions, you said earlier that they were instructed that the possession must be the September date, not the July date. So, I mean, you can't have them follow one set of instructions and it's okay to not follow the other. I mean, were they or were they not specifically instructed about the possession on that specific date that was charged in the indictment?
So that's the problem, is that if the jury said, as Judge Dyer said, if the jury said, if there's one juror who says, "I don't believe there was a gun," then that would be okay, but we know that didn't happen. Because
How do we know that?
Because they unanimously found he did have a gun. They unanimously found that he had a gun on this date.
On that date, not the prior date that was shown in the video.
Which is the difficulty, right?
I understand,
Because-
but they were instructed it was on that date.
But they cannot, so the only way that they can find that gun exists is if they reach two different decisions on the different counts, right? Which is an inconsistent verdict. But in a case like this where you have the potential, right? We have to prove on appeal that the admission of the previous video was an error, and that error prejudiced a substantial right? And in this case, the prejudice is shown by the fact that the jury reached different verdicts. Maybe it's helpful if we don't think about them as inconsistent verdicts, but if we think about them as different verdicts, that the jury reached two different decisions about what happened here. And the only way to do that is if they gave impermissible weight to that prior possession.
But that's, and I think this is, and I understand your argument, but I think this is exactly why the law says that put it simply, there's nothing we can do about inconsistent verdicts. There's nothing wrong with inconsistent verdicts, because while you're making a great argument, your argument is completely speculation. And the state, when they respond, their argument is completely speculation, because no one knows what took place in that room. And no one knows why they reached the verdict they reached. And so that, in a very simple form, that's why we have to say, the law says, inconsistent verdicts, there's not much you can do about them.
And in that, so that I think,
Unless there's just not proof to support it. Unless it's just not sufficient. Like if they find a verdict, they find it and they say it's, and you go, well, looking at the record, there's no way they could have found it because there's no proof of it. That's different. But here, there's proof of a gun. There's proof of an assault. just because they didn't match the two to an aggravated assault and a possession of a gun, we don't know why, but they didn't. But there's proof for both of them.
And what Your Honor's highlighting, I think, leads us into the second issue, which is what you're highlighting is the reason why it was so harmful for trial counsel to not object to this, because by not objecting, we have created this issue. So,
Well, I don't want to move you off of your inconsistent verdict issue, but since you just brought it up, you've now raised an ineffective assistance counsel claim on direct appeal.
yes,
And I guess my first question to you is, does your client understand that now is going to limit at some
Yes.
level his post-conviction
Yes.
should you not win this appeal?
correct.
Okay.
And so, to that end, the trial court, in finding this, so the issue, of course, is how did we get to this argument that we're having right now? And that is because trial counsel failed to object to the prior gun. The prior gun, as we know, the case law is plain, that possession of a different weapon on a different day is not relevant evidence. In addition to a 404 issue, it just simply isn't relevant, right? And in this case, trial counsel explained that he did not object because he had a strategy of showing the jury that the guns were different, right? Now, that strategy was... The trial court makes somewhat of a confusing ruling because the trial court rules that strategy was reasonable and then rules that, and I quote, the evidence was very relevant to the material issue of whether the defendant owned the same firearm around the time of the alleged offense. And that's in the record at 64, in the written ruling. And so the trouble is that the trial court has found, the factual findings of the trial court are problematic because the trial court has found that it was a reasonable strategy to argue the guns are different and the guns are the same. And so if the guns are the same, then it is not a reasonable strategy. And I'd suggest to the court that the strategy of comparing the guns is inherently an admission that he had guns. If you're saying it's a different gun, you are conceding the felon in possession. That is respectfully, not a sound and sensible trial strategy to concede the felon in possession. It is a better strategy to have the jury hear about fewer guns. Because that's what we're saying, was it a reasonable strategy to tell the jury, hey, that gun, he had a gun, he just had a different gun, is not a reasonable strategy when compared to the strategy of saying, we should not tell the jury about the other guns he has. That's not a sensible trial strategy. And it's seen in the jury verdict because, as we have discussed at length, the jury found him guilty of being a felon in possession, and I would submit to you that was in part because of trial counsel's strategy of saying, yeah, it's a gun, it's just not the same gun. That is not a sensible trial strategy. It is not entitled to that deference, especially when the law clearly establishes that this is not relevant evidence, that there should have been a 404 argument. It is a little hard to tell from the court's ruling whether the court found this was a different gun or not, but that issue should have been raised. That issue should have been raised because it is the only reason that the jury heard about this other gun. The only reason we're having this debate about the inconsistent verdicts is that the jury was told about guns it didn't need to hear about. And on a trial strategy of, I did the crime. And that is not a sensible trial strategy and should not be entitled to deference. And for that reason, there is a probability of a different outcome. And that probability of a different outcome is sufficient to undermine our confidence in the outcome. That we cannot be confident that this outcome was a fair and just outcome, and that it wasn't based on this unacceptable evidence that was admitted on respectfully, a poor strategy. And it doesn't give me any pleasure to be critical of another lawyer's trial strategy, but in this case, it is impossible to see a path by which that argument results in the jury finding your client did not possess a handgun.
What other proof in the record was there of the defendant's possession of the gun in the charged count, other than the victim's testimony?
The only proof in the record was her testimony. And that's why I think the jury's rejection of her testimony is important. That's why I leaned so heavily on it in my first issue, was the jury's rejection of her testimony, because there is no, the other testimony essentially was that the officers arrived and they located Mr. Bennett and they arrested him. There was not a weapon recovered. The only source of proof of the existence of the weapon was Ms. Pelcher said she had seen it or had been threatened by it, depending on how you would credit her testimony. So in that case, there's a clear difficulty in saying that there's no probability of a different outcome. And for those reasons, we submit that the judgment should be reversed and that he should be entitled, at least at a minimum, to a new trial based on these errors with respect to the admissibility of the evidence. I appreciate the court's time. I think I'll save the remainder for rebuttal if that's all right.
Thank you.
May it please the court, Catherine Redding on behalf of the state. I'd like to just quickly clarify a few points on the facts of this case. The state's position at trial was that the gun in the video and the gun at the Taylor homes were the same gun. And as I understand the record, defense counsel was of the same opinion. I think that there is some confusion because in the trial court's order denying the motion for new trial, it seems to have misheard or misunderstood defense counsel's testimony at the motion for new trial hearing. Defense counsel testified that he had a strategy that he wanted to say. He didn't object to the video because he wanted to say at trial to the jury, Ms. Pelcher is lying. She never saw a gun at Taylor homes. She saw that video, and Ms. Pelcher is the defendant's ex-girlfriend. She saw that video, and I mean, the closing argument is in the record in this case. And what counsel said was, Ms. Pelcher is lying. She never saw a video at the Taylor homes. She told the police that she described the gun she saw in the video to the police and said that that was the gun the defendant had. But there is no proof that the defendant actually had a gun at Taylor homes. He also suggested to the jury that Ms. Pelcher was responsible for sending the video to the defendant's probation officer. So the defense theory was Ms. Pelcher lied, she was upset with the defendant, she had sent this video to probation and nothing happened. And so then when she saw him at the Taylor homes, she called 911 and said she saw the gun and it was the same gun from the video. So I think the trial court seemed a bit confused about defense counsel's testimony, so I think that's where some of the confusion comes from. But the testimony at the motion for new trial hearing and then the arguments at trial all indicate that both the defense attorney and the prosecutor were arguing it's the same gun, or that the gun in the video matches the description from the Taylor homes. So just to clarify that point. So
would that be a reasonable strategy of trial counsel then, to not make some kind of objection to keep it out if it was the same gun? That's even more propensity type evidence.
Well, that was the, so that gets to the ineffective assistance of counsel claim. It's the state's position that the defendant is not entitled to relief on that because trial counsel made a reasonable strategic decision not to object to the video of the gun. I mean, as I said, counsel, his whole argument was Ms. Pelcher is lying, and he relied on the video to offer an explanation of how, we have a 911 call from Ms. Pelcher where she is immediately calling 911, and they're like, well, like, what happened? What did you see? And she, oh, the defendant has this gun, and gives it automatically, is just rattling off a description. And so counsel relied on that. And I think that it's the state's position that was a reasonable strategic decision. Ms. Pelcher's testimony was the only, as defense counsel has said, it was the only proof of the offense. And so the way to a reasonable decision on how to present a defense is to attack her credibility. And counsel, this was part of counsel's strategy. But even if this court were to disagree and find that counsel was deficient for failing to object, the second issue is that the defendant can't show prejudice, because he can't show a reasonable probability that the trial outcome would have been different had counsel objected to the video. And so this state's position that the trial court, that there's no breach of a clear and unequivocal rule of law by admitting this video, and that it is that the defendant can't show a reasonable probability the trial court would have excluded this video. But even if the court had granted the motion, had excluded the video, the defendant still can't show a reasonable probability that the trial outcome would have been different, because we don't know exactly what the jury was thinking, nor should we try to inquire into their deliberations. But what we have is Ms. Pelcher, the only witness testifying she saw the defendant with the gun. We have a jury showing with its verdict that it found her credible because it did find that the defendant had a gun. It convicted the defendant of assault and 2 counts of unlawful possession of a weapon and evading arrest. The fact that the jury declined to return guilty verdicts on all of the charges does not necessarily mean that the jury found her incredible. I think that this is a case, and the court will have the record, but it is more likely that the state just didn't prove aggravated assault.
Did the court give any instruction on how they can view the video versus the testimony?
So I don't recall a contemporaneous limiting instruction, but we do have an instruction to the jury during closing the final instructions, where the court told the jury that the state had to have proven beyond a reasonable doubt that the defendant had been set out the elements for the unlawful possession, but specifically says, just to be clear, we're talking about the date of September 16th, 2021 at Walter P. Taylor Homes, not the video. So there wasn't this, you can't consider just because he had it then, he had it now, but it was very clear to the jury that in order to find the defendant guilty, he had to find
that he had the gun that day.
That day, not that he had it in the video. And it was very clear to the jury the video predated the offense date by several months, because the jury heard from the probation officer or supervisor that she received the video in either June, I believe it was June or July, and it was also clear the offense occurred in September. So that was clear to the jury. And so it's the state's position the defendant has not shown both Strickland factors for ineffective assistance of counsel. And then going back to his kind of attack, basically just on the admission of the video, the defendant concedes we're up on plain error review, and I think the defendant has to establish all 5 factors, and this is a case, it's rare, but this is a case where we have testimony from trial counsel that they made a strategic decision not to object. And so this is a case where this court can find that the defendant cannot show that he didn't waive the issue for tactical reasons, because we have that testimony for counsel. But the state's position is, even if this court finds that that's not, disagrees, that he can't show the breach of a clear and unequivocal rule of law. The video was relevant because it showed that on the day prior to the offense, he had access to a gun that matched the description, made it more probable that he possessed the gun, but more important, he can't show that a substantial right was adversely affected. Evidentiary rulings ordinarily do not rise to the level of constitutional violations. Again, he can't show the tactical reasons, and he can't show that consideration of the error is necessary to do substantial justice, because, as I said, the jury heard that the video was filmed at least several months prior to the offense. It was aware of this timeline, and it was instructed that it had to find the defendant, if it was going to find the defendant guilty of unlawful possession, it had to find that he had the gun at the Walter P. Taylor homes, not that he had it in the video. And the jury's verdict demonstrates that it carefully considered the proof at the trial. It didn't just convict the defendant because it saw this video. It, in fact, declined to convict him of reckless endangerment and declined to convict him of aggravated assault, and instead only found him guilty of the lesser included of assault.
Can you help me understand? It's been a while since I've read the briefs, but you've got an indictment that charges this defendant with several crimes, all occurring on the same date at the same place.
Yes.
And one of them is ag assault, presumably based on him having a weapon, and the
Yeah.
other is possession of a weapon.
Yes.
What did the defendant testify at trial?
No.
So then I want to know, the state has the burden of proving the guilt of these crimes on this date at this time. What was the theory that the state would use in trying to introduce a video of this same defendant with a weapon at a different time, at a different place, other than to show he has a propensity to go armed? I mean, I can't figure out how it wouldn't pretty much be a blatant propensity type evidence that, and I realize this thing about strategy and, well, we wanted to show it wasn't this, it was a different one, but how do you get to the idea of a video of a guy with a gun at another time prior to this, at another place? How do you get to how did the state get to what theory did they have to say this should come in to prove his guilt of these crimes on this time? That's what I'm having trouble understanding.
Sure. And I will admit that my recollection of how this video, I don't recall there being a hearing. I think that makes sense given that the defendant didn't object, so there wasn't a full 404B hearing where counsel for the state had to make an argument. It really just came in. And obviously the record will speak for itself, but I can't recall whether the state articulated a specific reason to support the
reason,
video.
I guess the main reason I'm asking this is obviously the lady who testified that she was assaulted, and we've got some different interpretations apparently of her credibility by the jury's verdict, this, that, and the other, but he was convicted of, and I guess it's probably the most serious of the offenses, having a weapon as a prior felon or whatever that charge was. He was convicted of that, and so the weapon issue is a pretty important issue, and you sort of get to the idea that his argument would be, well, it sure bolstered the state's case to show, well, this is a guy in a previous video who had a gun, so he probably had one this day too, and he goes around with a gun. And so I'm back to the jury. They're going, well, we're not sure what this lady, we don't know if we believe her or not, but what about, did he have a gun? Well, I'm not sure about this lady's testimony, but we got this video of him going armed, so we got some pretty good proof here that he probably had a gun. In fact, we think he had a gun beyond a reasonable doubt. I mean, it's not much of a extra step there to convict him based on that.
I understand the court's concern. I think that this is a situation, though, that we have the limiting, not the contemporaneous, but we have the instruction from the court to the jury. You cannot find him guilty just because, you have to find that he had it on this day. The fact that he had it before, you cannot find him guilty based on that. We have a jury that did not return guilty all the way down on the charged offenses. I mean, I don't think that there is I mean, obviously the defense position is that this bolstered Ms. Pelcher's testimony that that the jury found him guilty based on this video. But if you look at the jury's verdict, it declined to find him guilty of reckless endangerment. And I mean, Ms. Pelcher, and it declined to find him guilty of ag assault and just found him guilty of assault. And I think that if you look at it, it really does not come down to an issue of credibility, because it comes down to an absence of proof on the aggravated assault. We have Ms. Pelcher's testimony that she says that he pulled the gun out of his pocket and said, it's in the brief, I shoot you in your face, but never, points it at her. It's not pointed at anybody. So we have an issue there. We have a proof that he's approaching the area holding a gun in the air, but he's not pointing it at anybody. There's no firing of a weapon. So I think that the way to understand the jury's verdict, obviously, we don't know because we don't inquire. But looking at this, I think there's a very strong case that the jury did not rely on this video to convict the defendant of the unlawful possession, that it relied on Ms. Pelcher's testimony, that it found her credible, and the defendant's up on plain error review. So even if it was, it's an evidentiary issue. It's one that defense counsel intentionally did not object to. He wanted this video to come in, or at least was very willing to to use it in his strategy. That was the crux of his defense strategy, was attack Ms. Pelcher's credibility, explain. You have more than just saying she's lying. She's lying, and here's where this came from. And he pieced the different pieces of evidence together as a vindictive ex-girlfriend who was mad at the defendant and had sent this video to probation to try to get him in trouble. And then she saw him and she called 911 and said, oh, he's got a gun. And she described the video and the gun because she knew he had it. And that was defense counsel's closing argument. That is not, there's no reading in between the lines there. That was what counsel said. So given that we were up on plain error, given defense counsel's failure to object, and the fact that we're talking about an evidentiary issue, it's the state's position that the defendant is not entitled to relief from the admission of the video, and that it was a reasonable strategic decision not to object, and even if it was deficient for counsel not to object, the defendant has not established a reasonable probability that the trial outcome would have been different had he objected, given what we can discern about the jury's feelings on Ms. Pelcher's credibility. So if there are no further questions, the state asks this court to affirm the judgment.
All right, thank you, General. Rebuttal, sir.
Thank you, Your Honors. If Your Honors please, that if defense counsel's strategy was reasonable, then the judge would have granted a motion to exclude. Because if defense counsel's strategy was reasonable, then it would be demonstrable that they are different guns, and the judge would have ruled, these are different guns, you cannot talk about different guns, the gun is excluded.
I think that's different than what you're arguing is different than what the state just said. The state said that not that this defense strategy was that are different guns, the defense's strategy was the only reason she's claiming he has a gun is because she knows of the video, that she had seen that. It wasn't, this is one gun and this is another gun. The only reason she gave a gun, she said there was a gun and gave that description was because she knew of the video. That's how I understood the state's reasoning of the defense's
That's what the
strategy.
record shows?
And that I do, and that's the big problem, because if I may, I wrote it down, the quote from the state's argument when my colleague said she told them about the gun because she knew he had it. Well, if you tell the jury in a felon in possession that the witness knew your client had a gun, that's going to encourage the jury to convict your client of possessing a gun. That's not a good strategy. You can't go to the jury and say, she knew he had a gun.
But if the trial
You're-
court says you have to convict him for having a gun that day, you can't convict him for having a video.
But the video is bolstering the credibility of. So let's take what the state's told you. The state has told you that the jury carefully considered what she said and rejected the portions of what she said, except for the portions that were. I see that I'm out of time, but if I may briefly.
Go ahead.
Rejected what they said, except for the portions that were backed up by the video. So if the video were not there, then they would have rejected the testimony. The video is what rescues that conviction from the jury's conclusion that she's not being, that there's no proof. However you want to consider it. The video is what rescues that. And the only reason that video is there is because nobody objected. And that's the problem, respectfully. Thank you.
Thank you, Counselor. Excellent arguments by both sides, good briefs. We appreciate that. We'll take it under advisement, render an opinion in due course. Next case, please.